If you're detained and trying to get out of detention, bond is one of the ways people get released while their immigration case is still ongoing. In this video, I'll explain what bond is, who can ask for a bond hearing, how to request it, what happens at the bond hearing, and what to do if ICE initially says no bond on your custody determination paperwork. Quick note. The information covered in this video is general information only, not legal advice. Bond rules can depend on your detention category, your case history, and where you're detained. The outcome will also vary widely depending on the judge that you are personally assigned at immigration court. With that out of the way, let's get started with talking about bond. To start with the big picture, let's talk about what bond is and what bond isn't. Bond is a way for you to ask for release while your immigration case is still ongoing. When someone pays a bond, they're making a money promise, a financial promise to the government that they will show up for their future court dates and follow release rules. If they follow the rules, the bond money can be returned later to the person who paid it, someone whom we call the obligor. Said another way, bond is not the same as winning your immigration case. Bond only decides whether you can be released from detention while you fight your ongoing case. So who decides bond? ICE makes the first custody determination soon after you're detained. As part of the paperwork ICE files upon your detention, they have to first make a custody determination on a form, usually a form I-286, where they will check a box on the form saying, A, if you're eligible for a bond or not, and B, how much the bond is for if you're eligible. On this custody determination form, ICE might set a bond amount, they might release you on your own recognizance, or they might write no bond, meaning that ICE wants to keep you detained or believes you're in a category where bond is not allowed. If you're eligible, an immigration judge can hold a bond hearing, also called a custody redetermination hearing, to review ICE's decision. At that hearing, the bond can be raised or lowered by the judge. Under current law, the lowest a judge can set a bond is $1,500. So if your bond is already set at $1,500, there's simply no point in asking for a judge to lower it beyond that. They can't. So who is bond eligible? Not everyone can get a bond hearing. Here's a simpler way to think about it. There are three common buckets. In bucket one are the many people who are bond eligible. This means ICE detained them under a law that allows a judge to review their custody. These people can ask the immigration court for a bond hearing. In bucket two are people who are subject to what's called mandatory detention. And this might happen because ICE claims that certain criminal history makes them subject to mandatory detention, or increasingly, depending on how that person entered the country, could be a reason that ICE is latching onto to say that they are subject to mandatory detention. Mandatory detention is an evolving category over time and is constantly being reevaluated. If you are subject to mandatory detention, the judge cannot set bond unless you first win a challenge showing ICE put you in the wrong category. More on that later. In bucket three are some people who are in a different kind of detention altogether. For example, certain people who just recently arrived in the United States or are close to the border, or where people have already been ordered removed by an immigration judge in the past and are again being detained now. In those cases, bond works differently or simply may not exist. In those cases, other release options might include parole or what we call an order of supervision. Again, more on that in other videos. And here's one more important reality to remember. ICE's label is not always correct. Often it can be wrong. If ICE says no bond or you are subject to mandatory detention or otherwise puts you in the wrong bucket, that doesn't automatically mean you have no options, but it does mean you may have to challenge ICE's category decision. Again, more on that later. Now, if you're trying to get bond, paperwork matters. If you can, try to get copies of at least 2 or 3 documents. Number 1, the Notice of Custody Determination, that Form I-286 that we talked about, where ICE writes the bond amount or says no bond. Number 2, get a copy of your Notice to Appear, the NTA. Number 3, if you have any criminal history, get the criminal court paperwork, especially the certified dispositions where possible. If you don't have this paperwork that I'm mentioning, ask for it. Ask ICE for copies, and if you have a lawyer, you can request records from them too, or they can help you make that request. Now, if you want a bond hearing, you need to ask for one. This is not something the court will just automatically schedule for you. So, how do you ask for one? Well, there are a couple of common ways to do that. The first is that if you attend what's called your master calendar hearing, you can ask for a custody redetermination hearing at your MCH. Second, you can send a short written request to the immigration court asking for that custody redetermination hearing, called a motion for bond or motion for custody redetermination hearing. Number 3, on that initial custody paperwork from ICE, that Form I-286 again, there is a box that you can check asking for a bond hearing. Now, if you take just this method alone, don't rely on it by itself. If you just check the box, follow up when you can to make sure that it actually happens. Also, remember this. There's no filing fee for requesting a bond. Paying the bond is different, but requesting the bond is free. Asking the government to justify why they detained you is a free request. So consider doing it. Now, if and when you get the bond hearing, it's important to know what to expect will happen there at that hearing. Because remember, a bond hearing is only about your release from custody. The judge is not deciding your whole immigration case that day. So what are they talking about? Here's a key strategy. Bring your strongest evidence the first time around, because in many situations, asking for a second bond hearing later is very hard, and you may need to show what are called changed circumstances to get another shot at asking for a bond hearing. So it's so much better to be ready than it is to be fast. Now, what do they actually focus on at bond hearings? At bond hearings, the judge focuses on just 2 questions, not your whole immigration case. The judge is looking for an answer to just these 2 questions. Number 1, are you a danger to the community if you are released? And to make this determination, they look at your past criminal history record, your record of breaking the law, and whatever rehabilitation efforts you've taken. Number 2, they focus on, are you a flight risk? Meaning, are you likely to miss court? If they release you, do they believe that you will come back to court to finish your immigration process? That's what the judge is trying to answer, danger and flight risk. If they think, no, you are a danger or you are a flight risk, then it's going to be much harder to get a bond, or you're going to get a very high bond. Because if they think that there is any ambiguity or gray, they are going to raise the bond against you to try to incentivize you complying. For example, if they set a bond at $20,000, they might believe, this respondent will be more likely to come back to court and not be a flight risk, because coming back means losing all of that money. An important detail to know about bond hearings also is this. Bond hearings are adversarial. That means that the government attorney will argue against your release, and they're going to do this based on those 2 criteria. They're going to say you are a danger, or they're going to say you are a flight risk, or both. And your job is to be prepared with evidence and a plan that shows you are not either one. Let's talk about what those mean specifically. Danger usually focuses on safety concerns. The judge may look at arrests and convictions from your past, at what happened and how recent it was. And the judge can also consider positive steps you've taken since then. Programs, counseling, sobriety support, work history, and letters from people who know you showing your rehabilitation. Flight risk is about whether you'll come back to court. And things that often help on flight risk include having a stable address, having a sponsor who can support you and help you get to court, close family or community ties showing that you are connected to this place, work history or a job offer, and a transportation plan for court and check-ins. That's what helps on flight risk. One practical point. A sponsor letter is often a very big deal. A strong sponsor letter explains how the sponsor knows you, this sponsor's legal status, where you will live, and how the sponsor will help you comply with the requirements of your release. Now, earlier we said that ICE can be wrong about which bucket your case is in. If ICE says that you're in mandatory detention and therefore not bond eligible, the judge may say they don't have authority to set bond because they don't have jurisdiction. But there may still be a way for you to get a hearing, and where a hearing where you can challenge whether ICE puts you in the right category, in the right bucket. And this hearing is sometimes called a Joseph hearing, named after a famous case from several decades ago. The point of a Joseph hearing is to argue that ICE is wrong and you should be treated as bond eligible. Now, Joseph hearings are incredibly technical and a bit beyond the scope of what this video is about. So if you believe that you or someone you know in detention is miscategorized, reach out to a qualified immigration attorney as soon as you can to get help. To wrap this all up, let's recap some of the big takeaways. For one, remember that bond is about release from detention while your case continues, and the bond hearing focuses on just two questions, danger and flight risk. If ICE says no bond, don't assume it's the end and don't just take them at their word for that, because often they can be wrong and there is an opportunity to fight them on that category. As a final warning, don't sign papers you don't understand, especially if you feel pressure to give up. Ask questions and get legal advice before signing anything. We hope this explainer video has explained the basics of bond. Please keep watching our other videos for more information about asking for bond and the bond process. Alternatively, please download our full Getting Out of Detention guide for more detail and examples. Thank you so much.